Welcome to the fourth video of a YouTube series covering the 2022 edition of A Detective's Guide to Interrogation Law. As we noted in the other videos, I'm intentionally giving away all of the substantive content of the book. If you watch all 9 videos and internalize the concepts explained in those videos, you'll have an expert knowledge of interrogation law without having to spend anything but your time. If you have not started with the first video, I encourage you to do so. It discusses evidentiary and constitutional provisions that will be helpful in understanding the more nuts and bolts content of this and other videos in the series. It also tells you about my background and describes some of the supplemental content that only appears in the hard copy book. If you've been through the first 3 videos, I suspect your head might be spinning from all the content. This series of videos has not been dumbed down, and some of the material will be intellectually challenging for even the most sophisticated and experienced detectives. But I am certain that the work that you have been put in by watching them has been worthwhile. You may not, for example, be thoroughly clear on the difference between Garrity and Kalkine's warnings, but you now know that special issues are presented when questioning public employees and know to stop and get oriented before proceeding further. Lawyers call this issue spotting. If an issue comes up, stop and rewatch the video, or better yet, consult that portion of the hard copy of the Detective's Guide and review the problem with your prosecutor. The book is bargain priced and available for purchase on Amazon. For most folks, because of the extensive case examples and comprehensive index, it is easier to use as a reference tool than the YouTube videos. But if you choose not to buy the book, the free YouTube videos stand on their own and provide real value to viewers. In summary, I think we have the best of both worlds here. The free YouTube version of the book can stand on its own and provide real value to viewers. If you watch all 9 videos, you are going to learn a lot about interrogation law. Investigators who are serious about further developing their interrogation skills will still be motivated to buy a copy of the book and/or to urge their departments to buy it. But in any event, I will feel rewarded in being able to pass this information along to a wider audience. If officers are able to use these techniques to make cases and take criminals off the street, I'm a happy guy, whether or not I make a buck off of it. So, on to today's lesson. This is video 4, which covers the Miranda Rule. The Miranda Rule can be concisely stated. Confessions are inadmissible in the government's case in chief, where a law enforcement officer interrogates a suspect who is in custody, that is, there's a police-dominated atmosphere, without first advising the suspect of certain constitutional rights and obtaining an express or implied waiver of those rights. This video begins by explaining the initial 3 elements of a Miranda claim: police involvement, interrogation, and custody, and then breaks down the many issues surrounding proof of a Miranda waiver. It is helpful to bear in mind while watching this that Miranda issues are resolved using an objective standard, that is, what a normal person would conclude from the circumstances, rather than a subjective test, that is, what did the person actually believe or intend. The Miranda Rule is intended to regulate law enforcement officials, not private citizens. There is no police-dominated atmosphere without police. This is a narrower class of persons than that subject to the Due Process Voluntariness Rule or the Sixth Amendment right to counsel. Those protections apply to any state actor or agent of a state actor. Miranda is limited to law enforcement officers. So, a private security guard is not a law enforcement official. A private citizen acting under instructions from a law enforcement officer with no police officers present would not ordinarily qualify, since there would not be a police-dominated atmosphere. Similarly, mere government regulation of a profession, licensing, or a mandatory disclosure or reporting law does not make someone a law enforcement official under Miranda. Closer cases may be made where the questioner is a juvenile counselor, school official, child protective worker, or social worker. Psychiatrists conducting forensic interviews at the direction of the prosecution qualify as law enforcement officials. Miranda does not apply to the interrogation of suspects in the custody of foreign officials in foreign countries, unless the foreign officials are acting under the direction of American authorities. A joint venture is required. There is a federal statute, 22 U.S.C. 2291C, sometimes called the Mansfield Amendment, that purports to regulate conduct by U.S. law enforcement in connection with foreign arrests and interrogations. But that statute is silent regarding remedies, and no courts have applied it to exclude evidence. The Miranda Rule does not apply to volunteered statements by the suspect. There must be interrogation. The Supreme Court defined interrogation in a 1980 case, Rhode Island versus Innis, as words or actions on the part of the police, other than those normally attendant to arrest and custody, that the police should know are reasonably likely to elicit an incriminating response from the suspect. This is an objective standard judged from the point of view of the suspect. That means that an officer's actual intent to obtain statements does not matter. This Fifth Amendment definition of interrogation is commonly litigated in two scenarios. First, to determine whether a Miranda waiver is required, and second, to determine whether a suspect who has invoked a Miranda right has initiated a subsequent conversation. We'll talk about initiation later in this video. In real life, conversations are typically back and forth. A suspect may make a volunteered statement or ask a question. An officer's non-interrogatory response to such a statement or question is not interrogation. An officer's request for consent to search is not normally regarded as interrogation and may be done without Miranda warnings. Miranda warnings are not required for routine administrative or booking in questions. The key inquiry here is not the location of the interview. Routine questions are permitted outside the jail, and non-routine questions are subject to Miranda even if they are asked inside the booking facility, but rather whether the question was reasonably related to a legitimate administrative interest. Bear in mind, though, that form disclosures of finances for bail or qualification for court-appointed counsel may trigger Sixth Amendment or statutory right to counsel concerns. The United States Supreme Court held in New York v. Quarles, 1984, that there is a public safety exception to the Miranda Rule. Officers must have a reasonable belief that, 1, the defendant might have or recently have had a weapon or other dangerous object, and 2, that someone other than the police might gain access to that weapon and inflict harm with it. This exception covers circumstances where there is danger to the police, danger to the public, and probably danger to the defendant. The United States Supreme Court has not looked at a proposed rescue or emergency doctrine exception to the Miranda Rule, but state courts have agreed that it exists in some form, perhaps as an extension of the Quarles public safety exception. It comes into play where police are seeking to locate a kidnapping victim or where for some reason human life is in danger. Some courts may require that there be no reasonable alternative and that the questioning be non-coercive. The next element, custody, requires more than a mere restriction of freedom of movement. A restriction on freedom of movement is not custody unless it occurs in circumstances presenting a serious danger of coercion resembling a formal arrest. Once again, this is an objective inquiry taken from the suspect's point of view. The officer's subjective intent to arrest or otherwise restrict the suspect's freedom of movement is irrelevant if it is not communicated to the suspect. Generally speaking, the experience or psychological weakness of the accused are subjective factors that are not relevant in determining custody. It does not matter if the suspect is unusually meek or compliant. Such matters may be relevant to the issue of whether a Miranda waiver was intelligent or voluntary, but they are not relevant on the question of custody. there's one exception to this, a juvenile's age. A Supreme Court case, JDB versus North Carolina in 2011, held that it is a factor. It's not a dispositive factor, but it's a factor in analyzing custody where the age is objectively apparent to a reasonable officer. The place and circumstances of the interrogation are relevant factors in determining custody, but are not determinative. Courts have declined to find custody where the interrogation takes place in a patrol car or the police station. The suspect is clearly not free to leave because the interrogation occurs during a traffic or Terry stop. The suspect is handcuffed. The interrogation is conducted during the execution of a search warrant. The suspect is being treated in a hospital. The suspect is a jail or prison inmate. Courts have, of course, found custody where these factors exist, but the point is that none of these factors are determinative. Courts rarely find custody where the questioning occurs in the suspect's home or place of employment. Perhaps surprisingly, incarceration in a jail or prison does not in and of itself create Miranda custody. The issue commonly arises where the government plants undercover officers or informants in the suspect's cell or common area. As the Supreme Court explained in a 1990 case, Illinois versus Perkins, coercion is determined from the perspective of the suspect. There is not a police-dominated atmosphere or compulsion when an incarcerated person speaks freely to someone he or she believes to be a fellow inmate. This also may apply to police interviews of inmates. That is, it's possible for police interviews of jail inmate or prison inmates to be considered non-custodial and not require Miranda warnings. It should be noted, however, that jail or prison interviews without Miranda warnings that are lawful under the Fifth Amendment Miranda Rule may nevertheless be barred by the Sixth Amendment if the defendant has been formally charged. This is discussed in considerable detail in the next video. Questioning at the border or at airports is treated like a traffic stop. A suspect may reasonably believe that he or she is not free to leave, but would understand that the detention is normally temporary, so it is ordinarily not custodial. Now, none of these things are guaranteed to result in a favorable ruling, and some may be impractical or tactically unwise in certain circumstances. But here's a short list of steps you can take to help avoid a finding of custody. Tell suspects that they are not under arrest and are free to leave. Make sure that they understand that they have access to food, drinks, and the restroom. Remove the handcuffs. Minimize the visibility of firearms. Keep the door unlocked and make sure that the suspect knows that it's unlocked. Take breaks and leave the suspect alone for brief periods. Keep unessential personnel out of the interview room, especially if they are in uniform or bearing arms. Conduct the interview at the suspect's residence or job site, or let the suspect decide on the venue. And of course, document all of these favorable circumstances in your report. Police officers should give Miranda warnings when interrogating suspects who are in custody. The officer or their agents question suspects after the Sixth Amendment right to counsel is attached. We'll talk about that in the next video. Or when questioning suspects who have initiated further discussion after an invocation of Miranda rights. There are exceptions to this last one that we'll talk about later, but it is better practice to obtain fresh Miranda waiver after any invocation and initiation. A fresh set of warnings may or may not be required after a significant break or change of scene. There's no strict rule regarding how long a waiver is effective. The required Miranda warnings should convey the fully effective equivalent of the following rights: the right to remain silent, anything you say can be used against you in court, the right to talk to a lawyer for advice before we ask you any questions, the right to have a lawyer with you during questioning. If you cannot afford a lawyer, one will be appointed for you before any questioning if you wish. If you decide to answer questions now without a lawyer present, you have the right to stop answering at any time. Different departments may have different formulations of the warnings. The warnings I just gave is the phrasing used on FBI Form FD 395. If you go back and read the 1966 Miranda decision, you will see that the Supreme Court used the phrases may be used and can be used, can and will be used. Courts are fine with either may or can and will. Can and will is actually factually incorrect. Defendants often say things that are not used against them, but there's no harm in using that phrase. There have been many reported cases where officers accidentally omit or misstate one of the warnings. Many officers carry wallet cards and read from them to avoid any errors. Officers who do not do this should be absolutely certain that they use the precise language and be prepared to explain later under cross-examination why they did not read the rights from a Miranda card. All that being said, the Supreme Court has held on a number of occasions that the precise language of the warnings is not a, quote, talismanic incantation, unquote, and that they should not be construed like a will. The basic requirement is that the suspect be given a fully effective equivalent of the warnings. Now, logically, one might think that officers should be allowed to omit the warnings for judges, lawyers, peace officers, or omit the part about free attorneys when warning rich people who don't need or qualify for free lawyers. However, the original Miranda decision has language in it that makes this a bad idea. It states specifically that the court will not pause to inquire in individual cases whether the suspect was aware of his rights without a warning, and that whatever the background of the person interrogated, a warning at the time of interrogation is indispensable, and that no amount of circumstantial evidence that the person may have been aware of the right to counsel will suffice. There is case law excusing warnings where the suspect is accompanied by a lawyer, or where a recalcitrant suspect interrupts the warnings by claiming to already know them. But these are close cases. You don't want to go there. Omitting the warnings creates unnecessary litigation risk. Insist on providing formal Miranda warnings for custodial interrogations, no matter what the surrounding circumstances are. The government must do more than simply show that Miranda warnings were given. It has the, quote, heavy burden, unquote, of showing that the defendant made a voluntary, that is, a voluntary relinquishment, an intentional, and an intelligent, or sometimes described as knowing and intelligent, waiver of the right to remain silent and the right to counsel. So let's look at these separately. Practically speaking, the voluntariness of a waiver is judged by the same standards as the voluntariness of a statement. All of the voluntariness principles we discussed in the second video apply when evaluating the voluntariness of a waiver, including the state action requirement. A knowing and intelligent waiver is normally shown by having the officer testify that the arrestee received Miranda warnings, was asked if he or she understood them, and gave an affirmative response to that question. The question about understanding the rights appears on every Miranda rights form. A positive response to that question is a critical factor in proving an intelligent waiver. Omitting that question is inexcusable. When courts talk about an intelligent waiver, they don't mean to suggest that the government must prove that a waiver was a smart thing to do. In fact, most criminal lawyers tell their clients to assert, not waive, Miranda rights. An intelligent waiver nevertheless occurs where a suspect possesses the capacity to understand the warning and to act in response to it, even if his or her understanding of all the ramifications of a waiver is faulty. Consequently, waivers may be knowing and intelligent where the suspects do not know what crimes the police intend to talk about, do not know about the existence of arrest warrants, or where police don't advise them that attorneys have been hired on their behalf. Sometimes suspects tell their interrogators that they will talk, but they won't sign a statement, or that they want to limit the interview to a particular crime. If honored, these requests are actually viewed by courts as evidence that the waiver was intelligent. Such distinctions may perhaps be characterized as stupid but intelligent. Miranda warning cards typically end with a question. Having these rights in mind, are you willing to answer questions? If that question is asked and an affirmative response is obtained, the suspect has expressly waived his or her Miranda rights. An implied waiver may be shown even if that question is not asked, so long as the suspect has acknowledged that he or she understands the rights and proceeds to answer questions without invoking the rights. Implied waivers have been found even where arrestees refuse to sign waiver forms or refuse to reduce their confessions to writing. Juveniles may validly waive Miranda rights, although youth and inexperience are considered to be negative factors in the totality of the circumstances. The more important point is that states are likely to have special rules based on statutes or the state constitution regulating the interrogation of juveniles. These regulations typically require the notification of parents. Officers are presumed to be aware of these state rules. The federal parental notification statute is 18 U.S.C. 5033. It requires juveniles in federal custody to be immediately advised of their rights, that the juvenile's parents, guardian, or custodian of the juveniles be immediately advised of the juvenile's rights, that officers comply with any requests by juveniles to speak with parents or a parental surrogate, and that the juvenile be brought before a magistrate judge forthwith. As technology improves, the electronic recording of interviews has become commonplace. The FBI requires recordings for all pre-arraignment interviews of persons arrested for federal crimes in a place with suitable recording equipment. Many states have similar rules. Where available, such recordings provide an excellent opportunity to demonstrate a waiver. Even in jurisdictions where recordings are not required, officers still use them with cooperative defendants to memorialize the statement and get acknowledgments of the statement's voluntariness. Never record accomplices together, though. It needlessly creates confrontation clause problems if the accomplices are later tried separately. The original Miranda decision suggested that the right to remain silent is invoked if, quote, the individual indicates in any manner at any time prior to or during questioning that he wishes to remain silent. For years, some courts took this to mean that ambiguous references to the right to remain silent or the right to counsel were sufficient to cut off questioning. Others permitted so-called follow-up clarifying questions to confirm that the arrestee really meant to invoke Miranda rights. All of this changed in 1994 when the Supreme Court delivered its decision in Davis versus the United States. That court indicated that it is, quote, good police practice, unquote, to ask clarifying questions after an ambiguous invocation, but they are not required. Examples of ambiguous invocations that have been lawfully disregarded by interrogators include questions about whether the right should be invoked, a stated intent to hire an attorney at trial or to sue the police, an expression of fatigue, mere silence in the face of questioning, a refusal to sign a waiver or reduce statements to writing, a request to talk about one crime but not another, or a refusal to talk to one officer but not another. A suspect who attempts to selectively or conditionally waive rights or otherwise control the interview does not make an unambiguous invocation. To the contrary, it is evidence of knowledge of the rights and the ability to exercise them. But on the other hand, clarifying questions won't undo an unambiguous invocation, and later statements or waivers may not be used to create ambiguity after an unambiguous invocation. In other words, you may but need not ask clarifying questions if an invocation is ambiguous. If the invocation is unambiguous, however, clarifying questions are not allowed. There is nothing to clarify. In those cases, you must honor the invocation. Police are not required to honor invocations that are not made in the context of a custodial interrogation. This would occur, for example, where the suspect is not in custody, or if an arrestee is not being interrogated at the time of the invocation, even if Miranda rights are provided at the time. There must be custody and interrogation. These are called gratuitous or anticipatory invocations. Police are not required to honor invocations by family members or the suspect's attorney. Accommodating or denying a suspect's request for a parent or other family member is a circumstance properly considered in determining whether a confession or waiver is voluntary. As we noted earlier, states and the federal statute may have special rules based on statutes or the state constitution requiring the presence or notification of the parents of a juvenile. Absent such a provision, however, the failure to honor a request for a parent or other family member is not in itself a Miranda violation. There are two types of invocations: invocation of the right to remain silent and invocations of the right to counsel. Each type has its own procedural rules. Police must scrupulously honor an unambiguous invocation of the right to remain silent. Having done so, however, they may approach the arrestee after a significant period of time and attempt to obtain a waiver of Miranda rights. Courts have not been specific about the minimum period of time, which might be affected by other factors such as a different interrogator or questioning about a different crime. A subsequent waiver may be difficult to prove, however, if the suspect is not provided with a fresh set of Miranda warnings for this second interrogation. A stricter Edwards rule, named after Edwards v. Arizona, 1981, applies to invocations of the right to counsel. Once a suspect in custody has made an unambiguous invocation of the right to counsel, further questioning is barred unless the suspect initiates the further questioning, the attorney is present for the second interview, or there has been a 14-day break in custody. Let's look at those circumstances separately. Initiation occurs where the suspect who has invoked the right to counsel makes a statement to the police that indicates a willingness and a desire for a generalized discussion of the subject matter of the criminal investigation. This initiation statement need not in itself be a waiver, but a waiver must be obtained before further questioning. An initiation cannot be prompted by an interrogation or a clarifying question that follows the invocation. This would spoil the initiation and the subsequent waiver. This is illustrated by the following exchange. If an officer says, having these rights in mind, are you willing to answer questions? That's a request for an express waiver. If the suspect responds, no, I want to talk to a lawyer first, well, that would be an unambiguous invocation of the right to counsel, thus triggering the Edwards rule. If the officer then responds, okay, but you will have to explain how the fingerprints got there, that would be an example of a post-invocation interrogation. If the officer responds, we can't get you a lawyer tonight, are you sure you want a lawyer? That's a post-invocation clarifying question. What's going to happen to me now? and there a suspect that would be an initiation that would have been spoiled if it was preceded by a post-invocation interrogation or clarifying question. As explained above, invocations of the right to remain silent and invocations of the right to counsel, that is Edwards invocations, are treated differently. Officers may reapproach the suspect and seek a waiver after an invocation of the right to remain silent, after scrupulously honoring the invocation for a significant period of time. But this is not permitted for invocations of the right to counsel. One might think that Edwards would be satisfied if the custodial suspect is then given the opportunity to talk to a lawyer after the invocation. But the courts say that's not enough. Mere opportunity to talk to a lawyer is not enough. Police may not approach the suspect for a subsequent waiver of interrogation after an invocation of the right to counsel unless the attorney is present for the second interview. A different circumstance is presented when the custodial suspect is released from custody after an Edwards invocation, even if the suspect is arrested again at a later time. After a break in custody long enough to give the suspect time to consult with counsel or other advisors, police may initiate a subsequent contact with the suspect. The break in custody dissipates the inherently coercive effect of custody that is the basis for Miranda. The Supreme Court, in a 2010 case, Maryland v. Schatzer, determined that this break in custody must be at least 14 days. As noted earlier, residence in a jail or prison is not necessarily custodial. Sometimes a custodial suspect who has invoked the right to counsel will later begin serving a jail or prison sentence. Lawful imprisonment imposed because of a conviction of a crime is not Miranda custody, so release back into the prison population would start the 14-day clock. Other officers working on other cases are bound by an invocation to the same extent as officers present at the invocation. It does not matter whether they were aware of the invocation. As discussed earlier, interrogators may approach suspects who have invoked the right to remain silent after a significant period of time if they scrupulously honor the invocation. Essentially, a second officer steps into the same shoes as the original officer. If the original invocation was scrupulously honored and a significant amount of time has elapsed, the second officer may proceed to obtain a waiver and question the suspect. In fact, the use of a different interrogator talking about an unrelated crime is sometimes noted as a positive factor in evaluating the subsequent waiver. Invocations of the right to counsel, that is, Edwards invocations, also put the second officer in the same shoes as the original officer, even if the second officer has no knowledge of the prior invocation and/or is seeking to question the suspect about unrelated crimes. If there is no initiation and the other exceptions to the Edwards rule do not apply, a valid waiver cannot be obtained. Such questioning is not banned in cases where the questioning is on separate charges and the requirement for a Miranda waiver is based upon the Sixth Amendment right to counsel rather than custody, because the Sixth Amendment right is offense-specific. We will explain that in considerable detail in the next video. So, you made it to the end. Thanks for that. If you have comments about the presentation or questions about some of the points I've tried to make in the video, I can be reached by email at contact@trialdex.com. This was the fourth and the longest video in a YouTube series covering the 2022 edition of A Detective's Guide to Interrogation Law. There's a lot of content in this video. To truly internalize it, you might want to read the case notes that are in the book. They help a lot. But I'm sure that watching the video has given you some helpful ideas on how to approach Miranda issues. The next video covers the Sixth Amendment right to counsel. There are some opportunities for interrogation described there that most officers, many prosecutors for that matter, don't know about. I hope to see you there.